you raise your right hand, state your name, spell your last name for me, please?
Charles Craddock, K-R-A-T-O-V-I-L.
And do you swear to uphold the truth in this matter?
Yes, I do. Thank you kindly. Again, my name is Charles Craddock. Thank you for the opportunity to speak tonight. It's an honor and pleasure to speak to you. Thank you to the attorney for noting my objection. I've been living in New Brunswick for 10 years. I have spent most of that time living in the 5th and 6th wards of New Brunswick. I helped to start a community organization called the 5th and 6th Ward Neighborhood Association there. I'm also the founder and editor of a community newspaper, New Brunswick Today. Before I get started, I just want to clarify that I'm probably not the last speaker tonight. I believe there'll be other speakers that are going to have some very interesting things to say, and I just want to make it clear that if conversation or testimony that happens later sparks another question from me or further testimony from me, that I will be allowed to come back and ask further questions after others have done that.
Yes.
Thank you very much, Madam Chair. Also, Mr. Fitzhenry, did you get a makeover? I noticed that Mr. Fitzhenry is not here, actually. There's another gentleman who I also know, Mr. Crum, who is serving on the planning board. Can I ask when Mr. Crum was appointed to the...
After the last meeting, I don't recall the exact date.
So within the past month?
Yes.
And my next question for Mr. Patterson, what are the procedures for appointments to the planning board and for making records of those?
Madam Chair, if I may.
Yes.
This is for public comment on the application. I understand that there may be procedural questions. I'm not sure how we want to handle those. Did you have...
I could begin with all the procedural questions I have and then save the testimony for a second.
If I may then?
Yes.
The normal procedure for the appointment of a new member is that the new member is sworn in and appointed and sworn in, and that has happened in this instance. The new member also is required, if they want to participate in the application that may be pending, and since this was a bifurcated application, but a continued application, would also have to listen to the tape, the audio tape of the prior hearing when we began the testimony. And I believe that's occurred here. Is that
Yes,
correct?
I have.
Okay, and so the appointments are made by the mayor in this case, and do they require the approval of the city council?
No, they do not.
Is there any requirement to notify the public of a new member being appointed to the board?
No.
Not from the planning board, no.
Okay, so there's no procedure for, say, updating the city website when a new member is appointed?
I think that this would not be the appropriate place to ask that question. We can only answer questions regarding what the procedure is for the planning board.
Well, I only asked because in the course of doing research for this, I looked at the city website and I did not see Mr. Crum's name on there, so I'm just asking why that's the case, why the city's website says that he's not on the board and that other people are. I mean, who is he replaced? When was the replacement made? These are questions that I think should be part of the record.
Certainly ask the questions. I don't know that anyone's going to be able to answer those questions.
Mr. Crum is replacing Ms. Ascona. As I stated before, I don't know the exact date, Mr. Crum. I don't know if you know.
I don't recall within the last 45
But
days.
it's been in the last, month or so that he's been appointed.
And does the city
I'm sorry we didn't get the webpage updated that fast, but that's probably not the top of the priority list. But I'm sure we will get to that very soon.
Okay, thank you. Well, congratulations on your appointment, sir. I do want to ask, has this application been properly vetted by the Technical Advisory Committee of the city?
Yes, the application has been in front of the TSA.
And can I have the date that that happened?
June 18th, 2014.
And just to be clear, that's a necessary part of the process for an application to make it before this first asserted by the Technical Advisory Committee?
Yes, and I think I stated from correct thought that was the date for the revised plans that we're considering tonight.
That's correct.
And it had been in front of the TAC for the previous plans.
Okay, and can you tell me when these plans were filed with your office?
Do you have them on?
date received appears to be June 28th, or is that
I think they must be, they're updated plans.
July 20th? I'm sorry.
Yeah, that's after that date,
After
so
that.
that's, they're updated plans.
Mr. Cradwell, when he's looking for that date, if you have any other comments.
I guess, well, I kind of need that date to move forward.
I understand.
I assume it's prior to June 18th? It's safe to say the plans were filed before the TAC meeting.
Yes.
Okay. And at that TAC meeting, was there an attorney present?
I believe there was, but I'll, maybe the applicant's attorney should answer that one.
Well, the applicant's attorney was there, I'm aware. Those technical review committee meetings aren't attended by a lawyer for the city.
So there was no planning board attorney?
There never is.
Thank you. I do want to raise a concern. So this would be an objection similar to one that was lodged at the last meeting. The objection that was raised was that Mr. Buca had been representing this board, and that in fact he had irreparably tainted the board with his advice, which I think at times was questionable. Certainly some actions he took when the meeting was overcrowded were in violation of the Open Public Meetings Act. And there were other pieces of advice that he gave the board that I think were not accurate, not good interpretations of the law. And I believe that it was said at the last meeting on the record that the reason that the board was going to deny that objection or reject that objection was that this is a new application. And I would like to raise your attention to the agenda for this meeting that indicates the application is PB 2013-25. And that application number is, of course, the application number for a prior set of plans. And in fact, the process for these new set of plans was presented to your office, Mr. Patterson, prior to June 18th, and that there was a TAC hearing on June 18th. While Mr. Buca was still the duly appointed attorney for this board, and that, in fact, there was not a subsequent application filed. We're still here on a hearing for 2013, or PB-2013-25. And in fact, if a new application were filed, would there not be a new application number?
What this is a update of the original application, but they have submitted new plans and the applicant is doing a de novo hearing.
And I'm suggesting that in order for it to be a new application, there must actually be a new application. And are there not fees associated with filing an application with your office for this type of hearing?
Madam Chair, if I may.
Yes, please.
And this may clarify, Mr. Cradwell, I believe that the issue that you're bringing up is different than what we've now addressed several times. The applicant is the same. The application number is the same. The hearing itself is a de novo hearing of a new plan that was submitted, I believe, in June. Is that correct?
May 30th.
May 30th. And correct me if I'm wrong, that plan has never been before this board for a hearing.
That's correct.
In August, is it not true that a hearing was convened for this application, 2013 PB?
I'm not aware of one, but regardless, we began the application anew in September. I'm sorry, what month is this? October. We began it in October. So all of the testimony that was provided was for the entire application from the beginning. The board members were also advised that any advice that they may have received or any information that they may have recalled from any prior hearings of a different plan that was submitted as part of this application was to be disregarded.
So my question about the fees was not answered. I'd like to know, are there fees associated with filing an application before this board?
I believe there are always fees with an application.
Yeah, there were always fees, and they paid the original fees back in November when they submitted.
A year ago, yes. So they have not paid a new fee for a new application.
No, they did not.
Okay.
For the new
So I would probably suggest to the board that the evidence here shows that, in fact, there's not a new application. You cannot magically make this a new application just because the applicant or his attorney has asked for it to be a new application. That, in fact, if it were a new application, there would be a new application number. There would be fees that would be paid to the city, to the planning office, and that the hearing would genuinely be a new hearing on new plans and a new application. But in fact, that's not what we have here. We have a situation where new plans were filed prior to Mr. Buca's recusal. The plans were filed, had a TAC hearing in June, a public hearing in August that, though it was short, was still a public hearing on this application and these newly submitted plans. And that, in fact, we are still operating, I just to draw your attention to this agenda right here, which says the application number is, in fact, the same as the prior application where Mr. Buca had tainted this board with poor advice. So I would humbly suggest, Madam Chair, that you or one of your colleagues make a motion now to revisit that objection and to take a vote on whether or not this truly is a new application, and whether or not that reasoning means that the board members, who are in large part the same board members who were there at the August hearing, are not tainted.
For the record, I'm going to object to that. I've listened to him now for 15 minutes. The board is well aware, as are the staff, that the counsel to the planning board never participates in any TAC reviews, any technical reviews. The board attorney is limited generally to when hearings commence. Mr. Buca's participation, while we disagree that there was any conflict, but Mr. Buca took the position that because this gentleman had filed an ethics complaint against him, that it was prudent for him to step aside. The applicant, though disagreeing with that, didn't want its application to be prejudiced as a result of actions that this individual took, and therefore indicated that it would start its testimony on the same application all over again. The plans that are before this board were never before this planning board previously. Despite what Mr. Cradaville says, the August hearing was objected to by Mr. Cradaville and the other objectors because the room wasn't big enough. There was never any testimony taken, and I object to, I think, what's intended to be misleading by his representation of what actually occurred. The fact of the matter is, all the testimony is new. We started over again in order to avoid any potential taint of Mr. Buca's participation, and he has participated in no TAC review or vetting of these plans that are before this board. And I object to the implication that you've got to now reconsider his request based upon those facts, because the facts that I just stated were made clear in the record at the last hearing.
If I may, is that not an objection to an objection?
No, it was an objection to a request that you have this board revisit its previous position, not your objection. You didn't object, you made a request. I objected to that.
Well, I object, and I would advise the board.
Okay, is
To
there anyone
please
else on the board
make a
who feels
motion.
we need to visit this issue?
Let me just say this. I don't recall any substantive involvement by Mr. Buca. I do recall that the August meeting was postponed due to the size of the room, that there was no testimony taken at that time. I do recall from the last meeting that there was a long discussion about a de novo hearing, meaning a new hearing starting from the beginning. So no, I don't think we should address it again. I think it's been addressed already.
I do not think so either. Is there anyone who thinks we should? Do you have any other objections?
Yes, I do.
Statements, sorry.
I do, and I would humbly object to the involvement of both of the individuals who just spoke against my last objection in these hearings. I'll start with Mr. Katniss. Mr. Katniss, is it true that you are the treasurer for the campaign for the mayor this past year?
That's
I'm
correct.
sorry.
It's public record.
Madam Chair,
Congratulations
Yes.
on your victory.
if I may, this portion is for public comment on the application and questions of the applicant or the applicant's witnesses. We are now going back in time to, and Mr. Cradaville was here at the August hearing as well, to apparently procedural objections and objections to further participation by board members, which could have been raised there, unless Mr. Cradaville can make a showing that this is new information that he's just received. And
As a matter of fact, it is.
if in fact it is, I think, if I may, Mr. Cradaville, if in fact it is based on procedural objections, then I would suggest to the board that what they may want to do is have other members of the public who wish to comment or question on the application be heard, and Mr. Cradaville can submit his objections after that's done.
Respectfully, if I may, I believe that jurisdictional objections can be lodged at any time. I took time out of my day to come to this meeting. It would be, I think quite frankly, ridiculous to hear tons of testimony only to have objections raised at the end. The objections ought to be raised first, and that's why I put those first in my remarks tonight.
Madam Chair, my suggestion to the board is that we hold off on the objections, the continuing objections that Mr. Cradaville is raising again for the second time.
Do you
If
have
the
any
board
other-
wishes to hear those objections now, certainly it's within the board's discretion to do so.
I didn't object to Mr. Katniss'
I
participation
understand.
previously.
Do we want to hear this now, or do we want to take other comments from the public and hear the procedural after? Doesn't matter. I think he's up here, let's hear it now.
Thank you very much. So where I'm going with this is, Mr. Katniss, in your duties as the campaign treasurer, did you have dealings with the New Brunswick Democratic Organization?
Madam Chair, I think we need to have the objections placed on the record. This is not an opportunity to cross-examine board members. If we can have the objections placed on the record, and if you wish to colloquy any of the individual members based on your objection and the stated reasons for those objections, that would be appropriate.
Yeah, I'm not trying to trick anybody here. I just think that
Just please state your objections.
my objection is that this board should not proceed because Mr. Katniss here is a official in the campaign of an individual who, it's my understanding, has in that capacity gained funding for that campaign from an organization that you're familiar with, the New Brunswick Democratic Organization, and worked closely with to re-elect the mayor, who appointed all of you to the board, and that in fact Mr. Kelso, who is here tonight representing the applicant, is in fact the executive director of the New Brunswick Democratic Organization, and that connection should be enough to force one of them to not participate. I've obviously raised issues about Mr. Kelso representing the applicant before. It is not for this board to determine whether or not he can, was his defense, and I respect that. But if he is going to be representing the applicant, and he is going to be here wearing one of his many hats, Mr. Katniss
We have handled that
has...
situation already, so do you have any other objections?
Yes, my objection is Mr. Katniss should not be representing the public here because he has an inherent conflict of interest by way of his dealings with the local Democratic organization that is one of its leading officials is representing the applicant. That is a clear conflict of interest that should require Mr. Katniss to recuse himself, and I would recommend that the board do what they can to make him do that if he's not willing to recuse himself on his own accord.
Madam Chair, I think we've gone over the objections based on the tenuous connection to the applicant attorney's involvement with this application and a prior board member, if I'm not mistaken. That's exactly the same connection that we're trying to make here. It's too tenuous a connection to say that there's a conflict of interest. And the conflict of interest laws are very much more specific. It can't be something as vague as what's being alleged here. What I would advise the board is that it's relevant to determine whether the conflict itself was with the applicant. And I don't think we've heard anything with regards to the applicant here, that there is somehow an inability because of Mr. Katniss' affiliation with a political organization, that somehow he's predisposed to making a ruling or a decision one way or the other, for or against the application, based on the applicant's attorney or his affiliation with the Democratic organization. If I understand that correctly, that's the crux of your objection to Mr. Katniss, is that correct?
Well, if I may elaborate just a little bit, there have been funds that have been transferred from the New Brunswick Democrat organization to an organization where Mr. Katniss is the treasurer. So he's accepting funds.
To the applicant?
That's different than the objections I raised before, where there was not necessarily a monetary exchange. I am raising this as a serious concern. Mr. Katniss has in fact said things at these hearings that were incorrect. He said that it was never on the record that Rutgers is a part of this project. I have here an exhibit I can introduce that shows, in fact, the housing for New Brunswick.
Mr. Cradical, if I could just cut to the chase here. How is the applicant involved here with that conflict of interest? Because that's the relevant issue here. It's the applicant that is before the board.
Right, and the applicant has made a choice to hire an attorney who has worked closely with Mr. Katniss in politics. And in fact, it's so close that money has been transferred from one organization to another. And that, in fact, it has already clouded Mr. Katniss' judgment. When the ethics complaint was first raised against Mr. Bucca, Mr. Katniss was the #1 defender of Mr. Bucca and said that he didn't even think Rutgers had anything to do with this project. And in fact, I approached him in the hallway after that and asked whether or not it was true that had been on the record that Rutgers was affiliated with this initiative to redevelop several sites in the neighborhood, and he remained silent. He did not answer my question. So I'm suggesting that he has already been tainted by not just Mr. Bucca's bad advice, but by his connection to the New Brunswick Democrat organization, by his connection politically to the applicant's attorney. The applicant has made a clear choice to hire an attorney who is very politically connected. It is a conflict. If the applicant had hired a different attorney, there might not be a conflict, but the applicant has made the choice to hire this attorney. Mr. Katniss ought to recuse himself. That is the least that he could do here.
Is there an objection to any other members participating based on that objection?
Yes.
And who would that be?
Well, first I'd like to have the board...
Why don't we get your objection on the record?
Okay. I believe that Ms. Sikora Ludwig, you are an elected committee member for your neighborhood, which is a great way to serve your community. But in fact, you are one of 56 people that have elected Mr. Kelso to be the leader of that organization. So I, again, lodge my objection that the chair respectfully should recuse herself because of connection to Mr. Kelso. And I would ask that if any other of the board members have participated in the Cahill for Mayor campaign, that they disclose that. Because I believe some other folks have accepted money, actual payments from the campaign. I believe Ms. Ascona-Barber has directly benefited from this flow of money from the New Brunswick Democrat organization to the Cahill campaign, and then eventually to her for campaign work. And that this has all happened very recently, around the time of this application. So I would suggest that that now makes 3 board members that would be tainted because of Mr. Kelso's involvement, which again, the board can do nothing about Mr. Kelso's involvement, but they can do something about their own involvement. I also need to raise the same issue I raised last time because I do not feel the board properly addressed it regarding Ms. Neubauer's questionable role with the Environmental Commission. State law requires there be a member of the planning board that serves on the Environmental Commission, and in fact, Ms. Neubauer has not participated in the Environmental Commission. She was not at the most recent meeting. She has not been at meetings for at least a year now. In fact, the board is already on thin ice with regard to this. After the passing of a great man, Bob Colonna, there were a 6-month period where there was no representative serving that role. And in fact, Ms. Neubauer is serving that role only on paper. She's not a member of the Environmental Commission if she's not attending the meetings. The point of the law is that the board will have a representative who is in touch, in communication with the Environmental Commission, and able to relay the concerns of the Environmental Commission to you folks, to her colleagues, and also so that she can update the Environmental Commission about the projects that the planning board is hearing. So I object to Ms. Neubauer's to this law being violated. This hearing should be ended right now, and somebody needs to serve that role in order for the law to be properly.
I believe that we had addressed that prior, but there is also a new member of the Environmental Commission, is that correct?
Yes, there is. Mr. Crum is a member of the Environmental Commission. Mr. Crum is the chairman of the city's Green Team, and he has agreed to be on the Environmental Commission and also serve on this board.
Madam Chair, that would mean that the planning board continues to be in compliance as it's required.
And Mr. Crum attended a meeting of the Environmental Commission? Yeah.
There hasn't been a meeting since I was appointed.
Okay. Well, I would humbly suggest that that does not mean you're in compliance. To be in compliance with the law, I believe that you would have to actually have a person who is serving that function of.
Well, he was just appointed, so he has to have a chance to go.
Yeah, I've got nothing against Mr. Crum. I'm just saying that
Yeah,
the board should not proceed. The board should not proceed because this function that is enshrined in state law has not yet been met. You're not yet compliant. Like I said, you've been on thin ice, and now moving ahead tonight would be a mistake. At the last hearing, you had not yet had that component of having environmental concerns brought to you by way of having one of your members on the board, and by having, again, someone only on paper so far serving that role. That's not good enough. I think that there's already been a lot of questionable.
Your objection is noted. Do you have any other that you want to get on record?
I do want to again object to your choice of attorney. I have respect for Mr. Athel, but I do believe that he too has a conflict because he mentioned his job. He has a business, and his partner in the business is the state senator, Bob Smith. And in Mr. Kelso's capacity as the New Brunswick Democratic Organization Executive Director, Mr. Kelso helps to get his law partner elected to a powerful elected office. And in fact, that law firm does quite well representing clients before planning and zoning boards. I think that represents a conflict. It's just not right for folks to proceed if the applicant has hired an attorney that they have that connection to. You can call it tenuous, but when you have 4 or 5 tenuous connections, that's a problem. And in fact, I don't believe they're tenuous. I believe these are serious connections. We all know that money, politics, and development work in concert, and in fact that the fact that you've selected an attorney who has a connection to, a business connection to a political official who benefits from Mr. Kelso's work, that means that your attorney may be compromised. He may not be the best choice. I think that he's a good man, but I don't believe he's the right choice for the board, and so I'd like to mock that objection as well. Additionally, I'd like to get some clarity on whether Mr. Kevin Jones will be participating in this here. No, is he planning on voting on this application?
No, he is not.
He's not. Can I ask, is that because he is also a member of the New Brunswick Housing Authority Board?
If he's not participating, I don't think that we need to explore that much further.
Okay, well, I would object to his involvement because he is a member of the Housing Authority.
He's not involved.
Which is already, okay. And I believe that is the extent of my objections.
Mr. Ital, do we need to vote on these or discuss these
Well,
issues?
if I may comment on at least the main objections to Mr. Katniss and participation of individuals who are affiliated in some way with a political party, which also happens to be the same political party that the applicant's attorney is local chair for. If we have addressed that question, that connection is tenuous at best to call for an automatic disqualification. There is no direct pecuniary interest here that results from any of the board members participating in a political party that is also the same political party that the applicant's attorney belongs to. The test, as I advised the board last time, needs to be much more direct. For instance, there has to be some connection to the applicant. The applicant itself is what this board is considering, not the applicant's attorney. With all due respect, Mr. Kelso may be a charming individual, but I think that the board members know their job is not to be charmed by an attorney, but to be cognizant of the application before them and to weigh the facts as they're presented by the application. And those are the witnesses that are presented. Mr. Kelso does not have a vote in this, nor does Mr. Kelso provide testimony that the board has to consider. Mr. Kelso is a conduit of information that the board may receive, and the board has an independent duty above and beyond that, and they will, if they feel that there are additional questions that need to be asked of the witnesses that are presented, and the board has to make a decision based on the information that it believes to be relevant for either in favor or against the application, or to perhaps seek additional information. Having said all that, there is no direct conflict of interest here. My opinion is that there is no reason for a recusal. We've already weighed the reasons for recusal or the limitation of further participation by me. I would ask that the board not raise that issue again, as it's a moot point. At this juncture, it's been asked and objected and resolved.
Do you have any other comments?
I do. I want to know if you were going to vote on my objection to Mr. Katniss, since that one's not yet
No,
heard.
you're not.
No?
No.
There was no motion made, I'm sorry, so the issue itself would, if there was a motion made to vote, then that would be considered, but I believe you'd asked, and just for clarification, if there was any motion, I don't believe that any motion was made.
Does anyone want to make a motion?
Okay, I think it would only be appropriate since other objections were granted a vote, but we'll move forward. I apologize. I have one more objection that I lodged in the previous hearings for this same application. And I do object to Mr. Kelso being involved in any capacity here because, in fact, in this very room, he serves as the county's counsel. He's the top attorney for the county government. He, in fact, is the chief advisor to the Middlesex County Prosecutor's Office, according to his private law firm's website. He's also basically represents nearly every aspect of the county government. And because this project could have an impact on Easton Avenue and County Road, because it obviously gives the perception that there is something fishy here. I think that Mr. Kelso should not be representing the attorney, and I know that he's already spoke to that objection in previous hearings, but I do want to lodge that for the record, since this is at least according to Mr. Kelso, a new application. And I do want to lodge that for the record, that I don't think it's right for him to wear so many hats. The political thing is one thing, but when you talk about representing the public and having a public job that pays you very well and it gives you an incredible amount of power, I don't think it's appropriate for you to also have a side job representing the biggest developers in the area and using both of those jobs to make a sizable income. I think that you should pick a hat and wear it. In this case, you've got to put the government first. If you're working for the government, you should work for the government all the time and not have a different job at night where you work for private interests.
Okay, your objection is noted.
Thank you.
Okay, any other comments?
Yes, I would like to speak to this application. I've become quite familiar with it. The first time I became familiar with it was when I was handed this piece of literature at the groundbreaking ceremony on September 19th, 2013 for the College Avenue Redevelopment Initiative. I was surprised to see a small chunk of land reserved for, quote, housing for New Brunswick Theological Seminary and Rutgers University Hillel. Can I ask the applicant, is there a deal with either of those two organizations, between his firm and those organizations?
This is just, you can make comments now.
I believe I'm allowed to question witnesses. Mr. Broder was a witness, no?
If I understand the question correctly, this is not intended for housing for Hillel, and it is intended to contain a component for housing for the Theological Seminary, and that still is what the expectation is. And they have had regular negotiations, and there is an expectation that there will be a final lease signed. Until a final lease is signed, I can't say to him that it's a done deal, because unless we get an approval, we can't sign a lease for it. So, but that is what's been testified to previously is still what the intent for the project is.
So, given that, in theory, within a year's time, the building could be built. Maybe the seminary rents some rooms, maybe they don't. And maybe they rent some rooms and don't like it, and a year later they move out. I think it's very misleading that the application has been presented as seminary housing when there's no promise that it will actually serve that function in any way. It can be said as the expectation, but that doesn't get you very far. A deal could have been made by now. You don't need an approval from the planning board to enter into a deal. In fact, it's my understanding that this developer is going to be providing housing to the seminary in the future, regardless of this building. And I think that it is really, really misleading. If we're to believe what we're told, 10 of the 52 units in the building would house seminarians. That is less than 20%. So to call it theological seminary housing based on an expectation that less than 20% of the units will be occupied by seminarians for an unspecified period of time is quite a stretch. I would use the word tenuous to describe that. I don't think that it's fair to consider this as seminary housing. I ask that the planning board please keep that in mind. There's no deal here. This could just as easily be 52 units of private market rate housing. And it's likely that could be the case. So I think that the board has been misled with that characterization of the building. I also have concerns about the parking. I agree that being near a train station is great, and it's great if you can encourage people not to have cars, but Mr. Olivo testified that Mine Street is at 100% capacity nearly every night, right? Is that correct? Is Mr. Olivo here to...
Good evening, Madam Chair, members of the board. Just for the record, Charles Olivo, O-L-I, V as in Victor O, of Stonefield Engineering and Design.
Madam Chair, you were sworn in last time, you remain under oath.
That's correct, yes.
So is it true that Mine Street is at capacity?
Generally in the evening hours, my observations are that Mine Street is, the on-street parking is sufficiently used, correct.
Sufficiently used means at capacity?
Generally at capacity.
Okay.
Agreed.
And will this project eliminate any existing on-street spaces?
Not to my knowledge. In fact, as I've testified previously, this project will essentially forfeit the need for on-street parking.
What I'm asking is the physical development of this project. currently, you can park in front of 17 Mine Street, 29 Mine Street, and the area in between. When this project's done, will you be able to park in that same area, or will there be a loss of those spaces to residents and visitors?
My understanding is that there would not be a net change in on-street parking, but I can certainly confirm that.
Yes, I think that needs to be confirmed before action can be taken. I think that the obligations under the RSIS standards show that you need to provide adequate parking. And if you're saying the street's at capacity and you're taking away parking, when I go to visit a friend on Mine Street and I'm given the visitor parking pass, it's going to be harder for me to find a parking spot, just like it's going to be harder for the other residents of Mine Street to find a parking spot. And I think it's a serious concern if any spaces are going to be lost, since we say we're already at capacity.
I certainly disagree with the logic that you just provided. I do not believe, and as I've testified before this board, with regard to the adequacy of parking, that this project does not need on-street parking to be sufficiently parked. As I mentioned in prior testimony, the 43 parking stalls that are to be provided on this site are sufficient to accommodate the parking demand associated with the project.
Now, when you say 43 parking spaces, it's really not 43 traditional parking spaces. There'll be 2 handicap-only spaces, correct?
There are 43 traditional parking stalls designed on this site. Traditional.
Okay.
And striped.
And will any of them be
lined.
restricted to handicap only?
As required by federal and then flowing through to state statute, there will be 2 ADA stalls provided.
So
For the members of this particular project, that could perhaps be handicapped and require those stalls.
Absolutely. I think it's great to meet those standards and to make the building disability accessible. I'm not disagreeing with you. The other issue is there's going to be 1 enterprise rent-a-car park there, correct?
For car sharing purposes, yes.
So,
And as studies have shown, and as I've mentioned previously to this board, what these car sharing studies indicate is that providing a car share such as this, which is very similar to the zip car concept, can have the effect of reducing car ownership. There's been a lot of testimony tonight about the need for a car to actually conduct grocery patronage, which is interesting because what these car studies show is that that is often the most frequent use of a car share vehicle. And what the studies indicate is that the reduction could be as many as 15 owned vehicles to 1 car share. So in effect, if you look at the parking stalls to be provided, there will be 43 parking stalls. 1 of those would be for car share. If you apply that reduction factor, actually increase factor, the 15, you'd be effectively providing 57 parking stalls on this site. More than 1-to-1, and more than, in my opinion, than you would sufficiently need to accommodate the parking demand here.
okay. So at the past hearing, it was said that there is a potential for 132 legal residents for the building. And so I just want to make it clear that those 132 residents, let's even say conservatively 100 residents would all have 1 enterprise rent-a-car to share for these purposes.
My understanding in speaking with the applicant is that if there is a need for an additional car share, that could potentially be provided as part of managing the facility, which I think is a great solution.
But what if there is, the deck is already at capacity? What if there's already, all 42 other spaces are spoken for, and then you're going to have 1 car that has to be shared by the remaining 60-plus residents, 70, 80, 90 residents. That 1 car is not going to provide an adequate resource because folks are going to have schedules where they need to get to the grocery store at the same time. And it just doesn't make sense that, if I lived in that building, I would say, oh, that's pretty much useless to have the car share because I could come down there at any time and the only car would be gone. Somebody else would have it.
In my opinion, and having relied on the Institute of Transportation Engineers journal articles, recent publications, parking is certainly a very popular topic of conversation amongst transportation and parking and planning professionals. based on current information and data that we've collected locally, those Institute of Transportation Engineers publications as well, I think the what-if hypothetical scenario that you heard is extremely unlikely to occur here.
Okay. I do want to say that and that's all I have for you, Mr. Legal, thank you. I do want to say that I share a concern with Mr. Nathan and Mr. Seelenfreund, who spoke eloquently in favor of the project. I share a serious concern about safety. And Mine Street and much of the 5th and 6th Ward has been recently plagued with a wave of crime. It's obviously not the first time that's happened, but I am tremendously concerned about the safety of the residents who will be parking in this underground garage. Just for the record, any person, a pedestrian on Mine Street, could walk into this deck, correct?
I'm not sure of the layout.
It's not like
Are you
a gate.
asking a witness?
I'm asking the applicant, yes.
Theoretically, yes, someone could walk in off the street just as someone could walk into any other building on any street where a door might be open or a garage is open at any given time. So the answer is yes.
For all of us who know the Mine Street and College Avenue area, it can get a little rowdy on Thursday nights, Friday nights, Saturday nights, and even during the day sometime, in the week sometime. But I think it is a huge mistake to allow for the construction of a building where there's going to be essentially secluded underground areas that any pedestrian can access freely all the time. It's not a matter of a door being left open, it's a matter of there not being a door or a gate. This would invite people from the community who may be under the influence of alcohol, who may go there seeking warmth, and those who may have who may have dastardly motives to go into the parking deck and wait in the parking deck to rob someone or to assault someone. And I just want to make clear that it's been testified in the last application, which the applicant insists is a different application, but I insist it's the same application, that there will be security cameras, but they won't be monitored. There won't be somebody watching them to make sure this isn't happening on Thursday night, Friday night, Saturday night, and that a young person or any person could be victimized in this parking deck and nobody's going to find out necessarily until the next morning. And yes, it's good that there's security cameras, but without someone monitoring them, this open air access to an underground secluded parking garage where a lot of young people living on their own for the first time are going to be is a recipe for a serious crime, for somebody to be hurt, for someone to be robbed. And I don't think that this design is what we need on Mine Street. I think that it's really a mistake to approve that. I'm very concerned about public safety. I'm concerned about the residents of the building and others in the neighborhood. And I just think that type of development is risky and ruthless. I think that there's better ways to do it. If you could have a gate on the parking garage, that goes up when people put a card in and it goes up and it allows people access, and it goes back down. But that has not been done in this case, and I think there's a serious public safety risk that the board would be allowing to happen if you vote in favor of this project. I encourage you not to vote it for one reason. Do not vote for this project because you could be endangering the very people who end up living in it. I also want to raise a concern that this is essentially a $1 million gift to the developer. The law says that they're required to build 96 parking spaces if they want to have this many units. they've said that that's possible. It's not impossible to build that many. It's just going to cost them an extra $1 million. By their own estimates, it costs $20,000 to $30,000 to build it one space. And so if they're already building a parking deck, they ought to build a parking deck that's the right size for their building. And I think that what they're asking for amounts to a very costly gift that gets them out of an obligation that might be somewhat expensive, it might limit their profits, but also sets the neighborhood up to perhaps not have adequate parking. I think that when you're dealing with a situation where there's already very little parking, and you bring in 130 residents, and you charge $1,000 for an apartment, most of those folks are just going to have cars, and they're going to bring the cars whether they can get a spot on the deck or not. It was said that it's a self-correcting issue, but I don't believe it's self-correcting. It could spiral out of control. You could have, maybe on the grand opening day, you might have enough spaces for everybody. But these are young kids. They're going to need to, when they graduate, they're probably going to get a job, and the job opportunities are very limited if you don't have a car. A lot of the good jobs are in the suburbs where there's no public transit access whatsoever. So you got to think about these people who are going to be moving in are going to want to improve their lives. They're going to want to one day maybe buy a car. And if they're living in a building where every spot is already taken up and you can't find space on the street and your landlord's already given up your right to get a parking permit to park on the street anyway, you're setting up people to not be able to live there and enjoy a good life. You're basically telling them that they're not going to be able to have a car because the deck may be at capacity. And so somebody who's been living there for years might be forced to either move or restrict their job searches very, very acutely. So I think that, similar projects have been built, and it's been said that some of them are doing fine, but there are others where there's a wait list, or where people, not everybody was able to get a spot. And I'm suggesting that as people move forward in their lives, the tenants in these buildings, they may move out because they want to get a car, but they also may try to get a car anyway. It may clog up the parking on Mine Street, and I think that that's a serious concern because folks, as they move on from college, in many cases need a car. And as has been said before, the grocery options in our neighborhood are very, very poor. The prices at the corner stores and convenience stores are outrageous. For folks who have a car, they can go to East Brunswick, they can go to Franklin, they can go to Food Town, they can go to Bravo, and conveniently pick up their groceries and drive back. Folks without cars are going to be paying essentially a very steep tax to live in this area, and I second everything that Mr. Larabina and Mr. O'Neill said. I think that Rutgers bus system is great. It's one of the largest in the country. By some measures, it's the largest. But Mr. Larabina hit the nail on the head. It's not comprehensive during the summertime. It's not comprehensive on the weekends. It's even very crowded, even when it's at its maximum. So that, just being near a Rutgers bus stop doesn't make it so a person can live there and get around adequately. They can get to the campuses during the weekdays pretty easily during normal hours. But on the weekends and during the summer or spring break or winter break, the bus options are severely limited. And I suggest that you might not want to necessarily subscribe to everything that you're being told by these experts because this is not a normal bus system. This is not the NJ Transit bus system that has a regular schedule and maybe for some holidays has some minor drops in service. This is a bus system that's primarily for university students and therefore doesn't meet the needs of a resident who's going to be a year-round resident. This building's going to be open year-round. It's not a dormitory. It's a building where people are going to live year-round, and those options are just not going to be there in the summer and in the winter and on the weekends. I also do think that it's worth noting that the properties have fallen into disrepair. It is disgraceful to see it. I called the New Brunswick housing inspectors myself to report when I noticed there was a hole in the building. 17 Mine Street. I know that the property owners, I don't believe they're here tonight, but I do believe that they are working in concert with this developer. And I will just say for the record, this document I was given, that was the first notice I got about this project, has the Rutgers logo prominent and the Devco logo prominent, and of course Devco controls the company that owns this land. And I would suggest that everyone who's a part of this project needs to put New Brunswick first. I think a lot of folks involved in the project might not make New Brunswick their home, and so it's very easy to neglect a property that's not in your neighborhood, not in your hometown, but we deserve better. Everybody deserves a good neighborhood, and quite frankly, the situation with those properties is disgusting, and I don't think that it's a fair argument to say you should reward the folks who own the properties and let them fall into this horrible state of disrepair by fast-tracking their project. In fact, they should be made to repair those properties and get them up to code before they can even get a hearing here. It's not right to allow negligence to be an excuse for passing a project. If they want to do their job and maintain their properties, then we can talk about maybe approving what they want to build there. But if they can't do that, why can we trust them? How can we trust them to maintain the properties into the future? And I would suggest that this building might be presented to you in 2014 as theological seminary housing, but in 10 years it could be a slum. In 10 years it could be sold to a different company or maintained by the same company. It could never have a single seminarian live in it. There's no guarantees about this project, and because of all the volume of questions that people still have about it and the lack of answers that people have about it, I think that you should hold off on approving it. You should deny it and send them back to the drawing board and let them come up with a better plan. One that's going to be safer and protect the residents, one that's going to make the neighbors happy and not seriously impact their quality of life and their ability to find a parking space for themselves, and ultimately for them to get their act in order and fix up this property that is disgusting. I think that there's no guarantees, or there hasn't been sufficient guarantees made to this board that this project is going to be good for New Brunswick. There's serious concerns that I have and others have, and I hope that you will take those concerns into consideration before you vote to approve this. I do respect everyone on this board, and I don't mean any disrespect when I object and say that some of you shouldn't be participating tonight. I know that you all in your hearts are going to put New Brunswick first, and I would humbly suggest that doing so includes voting down this project tonight. Thank you very much for your time.
Thank you.